what's happening with the ILR. What are the latest news and what is the latest update?
Recently, Shabana Mahmood, the Honorable Home Secretary, she gave an interview. They have asked about when this will be implemented. Initially, as per the earned settlement, and also. But the good news is, recently, during her recent interview, she said it's been moved to autumn 2026, which is a very, very good news. Not entirely, but at least she said the English level from B1 to B2, it will be.
One thing which you mentioned earlier, you said the Honorable Home Secretary has mentioned that this is going to be applied retrospectively.
People who will not be eligible after spring 26, they should prepare themselves for.
What happens like when they go into the judicial review or something? If they fail, then what happens?
See, if someone is on skilled worker visa and if they are going for settlement, what are the things they should be prepared?
What are the requirements for an ILR? Hi guys, welcome back to another episode of The Hatman. So actually we've been we thought that we'll not do more English episodes, but we never thought that people were waiting for our English episodes.
Exactly.
So there's been a lot of people asking us to put videos in English, though because I think that the Instagram has already started translating it, but in YouTube we have not figured that out yet.
All right.
Yeah, so what we have now we have decided is we are going to do a lot of English episodes as well, so that wider audiences are benefited.
That's right.
Okay. So again, hi, vanakkam, and welcome back to our episode. So this time we are going to discuss about the latest and the very hot topic.
Yes.
Before that, let me introduce you.
Thank
Mr.
you.
Badri Bala Venkateshan. He's a senior immigration lawyer. A lot of people who are already watching us on Tamil know about him, and he's helped a lot of students and a lot of skilled workers in the UK. He has more than 6,000 happy clients, and he has done IAA, which level 3 in IAA, which is one of the accreditation for becoming an immigration lawyer in the UK.
That's right.
Which means he can go and go to the court for any immigration related cases. Yeah, and he can represent you.
Correct.
So now because we thought that we have to know the latest from the man himself.
Sure.
We want to know what's happening with the ILR. What are the latest news and what is the latest update?
Sure.
Yeah.
So before that, I would like to introduce my company name,
which
is Universal Fortune Limited.
I wanted to give him something to introduce.
Yes. And our website is www.ufvisas.com.
Yes.
And the most important topic which everyone is talking about is settlement. And since the white paper was announced in May 2025, Home Office been implementing one by one. Out of that, the most critical part is earned settlement route. So recently, Shabana Mahmood, the Honorable Home Secretary, she gave an interview to the I think it's Times magazine, if I'm not wrong.
Okay.
And they have asked about when this will be implemented. So what she has said is, initially as per the earned settlement and also during the consultation which was finished on February 13th, they were saying that it will be implemented from April. And even in the parliament session, she did say it will be implemented in April. However,
in spring, that's what they said.
Yeah, spring, absolutely.
Yeah.
So, but the good news is, recently during her recent interview, she said it's been moved to autumn 2025. Sorry, 26.
Yeah.
Which is a very, very good news. Not entirely, but at least for the people who are eligible from April, from now till autumn, probably we do not know, it could be in September or October, they could be eligible and still they will be treated under the current rules. As of now, the rules haven't changed. So they can get their ILR within 5 years instead of waiting under 10 years. However, she has also said in the recent interview, which she gave announcement and it came in Sky News as well, what she said is it will be applied retrospectively. This is the first time after the consultation she has confirmed in black and white it will be applied retrospectively, and she did not mention will there be any transitional arrangement. It looks like unlikely. So it will be for all the people whoever came in the UK since 2021, and when this rule change comes on that day, if they have not qualified, then they have to wait for 10 years. But she also said there are ways to get reduced to 5 years. She said through the unsettlement model, like if you're paying higher tax and you're contributing to the society, speaking higher level of English, all these things. Now coming to that, another good thing is she said the English level from B1 to B2, it will be in effect from March 2027, which is a very good news. She has given a 1 year period. She said we are giving this transitional period, so people should prepare themselves. So I'm giving time. So you have to.
Until then, B1 is
yes,
okay.
Yes, B1 is okay. Until then, B1 is okay. So this is again another good news. But people who will not be eligible after spring 26, they should prepare themselves for 10 years. So when they are going for their visa extension, it is
autumn 26.
Yes, in autumn 26.
Then they'll switch to the 10-year route.
10-year route. So it's better they can ask their employer to give longer COS, like 5 years COS, instead of 2 or 3 years. So that will help them to kind of mitigate this increase from 5 to 10 years.
So now the one thing which you mentioned earlier, you said that the Honorable Home Secretary has mentioned that this is going to be applied retrospectively.
Correct.
But when we spoke earlier last time in Tamil as well, we mentioned that there will be a strong reference and consideration of all this consultation.
Yes.
Do you think that this has come after looking into the consultation, or?
See, the consultation outcome hasn't been officially published, but they are still in the process of announcing the final part of the consultation of whatever they gathered to announce. But the Home Office Secretary, they would have had an idea, and they are still would like to press this 10 years for retrospectively for people who are already in the UK. Now the point here is whether this can be challenged. Already we spoke last time in the Tamil program. We said they formed a kind of forum, and already around 8,000 people they have prepared to challenge this in the court, because there has been a case law in the past years which is called HSMP forum. So they want to use that to challenge it. Again, at the end of the day, the chances of winning, it's entirely up to the judge. But it is a case. There are some merits, but again, it can go both the ways. We cannot say that. So that is another topic.
So that's another topic, but that's an important question on that as well. So as you mentioned, that these kind of cases usually take longer to get solved. So for example, if someone is going to they will be first initially going to the High Court, and if it fails, then go to Crown Court. Then if it fails, then they go to Supreme Court. So for instance, it can take up to 4 years if it goes to Supreme Court. With the current timeline, it can take up to 4 years. But until then, these people, they have to continue staying in the UK. They have to work with the same employer, because let's say if their settlement is refused, then if the case is going on and during the judicial review time, your section 3C it doesn't kick in. So only until the admin review, because if a settlement under the SETO application, if it gets refused, you will be given only administrative review, and when the administrative review gets refused,
your Section 3C ends.
Yeah.
So either at that time they have to extend with their current employer, get additional few years of COS, and they have to do it separately, or if they
Leave the
are
country.
not working, no, leaving the country, because if they are going for an appeal, they
Yeah.
have to stay, and
Yeah.
during the judicial review process, your Section 3C doesn't kick in, which
Yeah.
means they won't be able to work.
Yes, that's right.
So there is a massive risk involved in it. So all the things they have to look into it. But
so what happens like when they go into the judicial review or something? If they fail, then what happens?
if they fail, then they have to leave the country.
That's what.
And
yeah.
let's say in meantime, if people do leave the country, because in the past HSMP forum, a lot of people left the country, Home Office did give them the visa
Okay.
again,
They
and they
came back.
said yes,
Oh,
and they
okay.
came back,
Okay.
and they said, okay, you again spend the period, and we will give you.
Oh, lovely. Okay.
So that is another possibility. Again, it's entirely up to the judge and how the case goes, what are the remedies they are asking.
Okay.
So that is something we need to wait and see. Now, let's look into if someone is eligible for settlement, what are the things they should be aware of, what they should do. Before we go, a disclaimer, this is not an immigration advice. This is purely for information purpose only. And for any immigration advice, you need to book a consultation with a qualified immigration lawyer and consultant like me or someone else who are regulated by IAA or SRA. Okay. So now let's see if someone is on skilled worker visa and if they are going for settlement, what are the things they should be prepared?
So are we talking about people who are going to qualify before the autumn?
Before the autumn.
Okay.
Absolutely.
Okay.
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 And if they are with their family, first we will talk about themselves as a main applicant who is on skilled worker. Then we will go to their partner.
Okay. We are going to continue on the requirements
That's
for
right.
ILR. Okay.
Absolutely.
Yeah. What are the requirements for an ILR?
Okay. So if someone is going to apply for an ILR before October 2026, or let's say autumn, whenever the rule is going to change. So the first requirement is they must have spent 5 years in the combination of either skilled worker visa or Ministry of Religion or Tier 1 entrepreneur or sole representative visa. In this combination, they should have spent 5 years in any of this combination, minus 28 days. Okay, so if someone, let's say in the UK, their first skilled worker visa was granted on 28th April 2021.
Yeah.
So they would be completing 5 years, which is on to 28th April 2026. So you take 28 days backwards. So from 1st April 2026 onwards, they can apply for settlement.
Yeah, okay.
Okay. So they must have spent 5 years continuous residency requirement they have to meet.
With any break, like there was a clause, right? Like
No, the break, yes, that's a good question. See, if this is something, there are two things you need to look into it. The Home Office does allow up to 6 months, 180 days they can be outside the UK as long as they have been paid in the UK. And there are certain exceptions, for example, if they are on the sick leave, those sort of things
medical
are there.
condition,
Medical
okay.
condition,
Okay.
that is, no, sick leave.
Sick leave. Okay.
Sick leave or maternity leave,
Yeah.
this sort of things where they can stay in the UK with lower pay or with the statutory sick pay. This is allowed. And the period they have, they can be outside the UK is 180 days.
That's
So
the
that is
maximum.
different.
Okay.
This is for the receiving less salary.
Okay.
As per the Home Office requirement, if you're reducing the salary, the employer must inform to the Home Office.
Okay.
Okay, A. And secondly, someone cannot be without pay for more than 20 days. So the another requirement is during this 5 years, in any calendar year, someone cannot have more than 20 working days unpaid holiday, which is like 4 weeks.
Okay.
And if they are being on holiday which is unpaid, then the employer has to stop sponsoring the migrant worker.
Okay.
But what Home Office is looking for is they should be actively employed during the 5 years, apart from the exceptions, which is like paternity leave or
Sickness.
sick leave, and apart from that maternity leave. So these things are allowed.
Yeah. Okay.
Okay.
Yeah.
Where if there is any salary reduction, it has to be informed to the Home Office. Otherwise, they should be fully paid.
Okay.
Now, the requirement is, first thing is that current salary should be at the going rate level as per the current immigration rules, where they have given table 1, table 2, table 2AA, 2AA. So, for instance, someone who has got their visa, let's say after April 2024, so their salary should be minimum 41,700 or going rate whichever is higher.
Okay.
Okay, but if someone has got their visa before April 2024, then their salary should be at minimum rate of 31,300 or going rate whichever is higher.
Okay.
So now a lot of people, they are in the salary when they went for their extension, for example before July 2025, they are still at 29k
Okay.
salary. I'm talking about these people who have got their visa in 2021.
Yeah.
So I'm talking about them.
Yeah.
They are at 31,300. They should have minimum 31,300. But let's say someone is on, someone working as a restaurant manager or someone working
So
as
when
a shopkeeper.
I'm confused here, because when you mentioned earlier, you mentioned that before April 2024 and after
April 2024.
Did you mean 2021 or 2024?
No, 24 only.
So okay.
So
Yeah.
the salary, I'm telling you what are the requirements.
Yeah. Okay.
So people who are coming after April 2024,
Yeah.
of course they will be eligible in 29. But I'm just telling you
Yeah,
the immigration
okay.
rules.
Okay.
But if we are sticking to the 2021 people,
So we'll stick to the latest one, because the one where they'll be
who will
okay
be until
before this.
October.
Yeah,
Okay.
until October.
So those people will be before April 2024.
Yeah.
Okay. So for them, the minimum salary going
Threshold,
rate
yeah.
threshold should be 31,300 or their going rate for the relevant SOC code, whichever is higher.
Okay.
If it is in the immigration salary list, then there is exception.
Yeah.
It is the 33,400 or going rate whichever in the immigration salary list is higher.
Okay.
Or if they are in the carer visa, then it should be minimum 25,000 pounds as of now.
Okay.
Or higher. If they are paying higher, that is fine. But minimum is 25,000. But let's say someone who is on a skilled worker visa, working as a restaurant manager or shopkeeper, or let's say they are working as a shop supervisor. Most of them, they are not even checking their salary.
Yeah.
And also people in the IT sector, they have got their visa extension, the salary before 2025 or 2024, whenever they got the salary was different then. But now if they are going for ILR, though they are meeting the skilled worker requirement, let's say I'll just give a example of a client who I was dealing with an ILR application. He came to us, and when I analyzed his file, he is working as a shop supervisor and his current salary is 29k and he is eligible for indefinite leave to remain next month. I've told him, sorry, you do not meet this requirement. So in order to meet the requirement, you should have minimum 31,300. So you need to go and speak to your boss and ask for a genuine increment. And if they are happy to increase your salary, then you can come back and we can do your settlement application.
So is there a time period they have to be in that salary for, like when they're applying?
There is nothing as such. As per the Home Office requirement, your recent pay slip, that is what they say, your recent 1 month pay slip is, but you cannot just do it for the sake of settlement. It should be genuine.
Oh, yeah.
Because Home Office look into the genuinity of any applications, they can refuse on general grounds.
Yes.
So you have to make sure the increment, the salary increase is genuine, and the employer is willing to pay for the foreseeable future. Then yes.
Okay.
So I have told the client to go and check with the employer, and if the employer agrees, then he can come back. So salary is one of the requirement, and you should not be out more than 180 days in any given year.
Yeah.
That is another requirement. Suitability, which is you should not be in breach of any immigration rules. You should not be in immigration bail, as well as you should not have any severe criminal conviction. And then
so when you talk about severe conviction,
yeah.
So usually I've heard this, maybe that those were rumors or like people didn't understand it better. Someone having points on their driving license.
Points on the driving license, it will not. You must declare any conviction or civil penalty you have. You must
Yeah.
do
County
it.
court judgment?
Anything you
Oh,
have to declare.
Okay.
Well, that comes under appendix suitability. This is a different topic. We will again cover that.
Yeah, we can
So
dive deep into
which one will be affected? But whatever conviction, civil penalty, whatever you have traffic offense, you must declare in your application. This is must.
Would that affect the thing, the application?
If it is some, yes, it can affect it depending upon, like I said, appendix suitability. It's a different topic.
Okay.
But points, speeding, as long as you declare, it shouldn't have any
Okay,
impact.
fine. All right.
Okay.
Anyway, as you mentioned, we'll discuss about it later.
In a separate topic.
Yeah, okay.
Okay. Then the next thing is you have to pass B1 English test. But since you are already in skilled worker, you will automatically qualify that English requirement. However, if you have dependents, they have to pass B1 level English test. Or if you have ICTIS, or which previously known as UK NARIC, then you get, if you have that, you no need to write again the B1 English test.
Okay.
Finally, life in the UK test. Okay. So these are the major requirements they have to look into it. But again, this should not be taken as immigration advice. We have to see each and every case on individual basis to assess it and tell them what other documents they need. It may be more or less. Okay. So these are the requirements for settlement. Now,
one thing, sorry to cut you there.
No, that's okay.
Now that people are rushing to get this, maybe there might be a lot of people who didn't know that they can go and do this application even before 28 days. And I know that you are getting a lot of influx of applications. Now, what are the mistakes people did? What exactly they are doing?
Okay, most of the time people, they apply too early. You can't apply too early. You can apply only 28 days before. This is one thing. And second thing is, most of the people, like I said, they don't check their salary in line with the going rate. This is the most important thing. And people, another thing, they do not declare. For instance, they would think it's just a traffic points, 3 points I done speeding. No, you have to declare it. Because if you do not disclose, they can refuse the application under deception that you have not been transparent and provided false information. Because you are saying, they are asking, do you have any offense including traffic or any other? You are saying, no, it's a false information. So these are the things.
So other thing, how strict are they about the number of days they can go out of the country? For example, someone goes out for 181 days. Would that count?
No, if there is under exceptional circumstances, we have done so many cases where, for instance, they have gone for during pregnancy, they went there and they couldn't come back because they had complications. And the doctor has said, if you travel, the child, it could be aborted. So it can fall for miscarriage. That sort of scenario. Genuine reason, health reason. Or for instance, let's say you went to India or your home country and your close family member, they were close to close to death, or they were going through a severe illness and no one to look after. There are, under exceptional circumstances, Home Office do consider if you go beyond 180 days. Otherwise, for instance, if you have just gone for work, or if you have gone for any other personal reasons, which is not exceptional circumstances, it will fall for mandatory.
Okay, so declaration is important with the reason.
With the reason and evidence, and it should be genuine.
Yeah, all right. Okay, fine.
Okay.
Yeah.
So this is what it is, and my suggestion and advice to the people, whoever is eligible, do not wait longer, because I see people who are eligible for indefinite leave to remain in 2025 August, September, and they still haven't applied.
Yeah.
So I tell them, please do not wait. If you are eligible either under 5-year route or 10-year route, because as per the Home Office new requirement, they're going to also remove long residency. If they are going to apply the earned settlement route, then there won't be even long residency will be in place, which is 10-year route.
Yeah.
So
who all come under this 10-year route?
10-year route, currently anyone who is on any legal stay, they can combine, for instance, a skilled worker, student visa, graduate visa, intra-company transfer, any visa they can do it, which is over 6 months. At least it should be 12 months. There, which are and also if you are going under long residency, your recent visa should have been granted for at least 12 months or more. This is a very important thing. And again, they have to meet the language requirement, suitability, those things. But the most important thing is, again, they can apply 28 days before from the day they entered the country.
And you mean to say that people don't know, they're not aware, and they are still
They are
thinking
just
that,
they are just being cool.
Oh, okay.
And I recommend you should, if you are eligible, you should apply.
Yeah.
Because if the rule gets changed
You
and
can't
you
do
do
that,
not
yeah,
apply,
yeah.
and as per the new rule you do not meet the requirement,
Yeah.
then you would have lost a wonderful opportunity.
Yeah, that's right. Okay.
So that's my takeaway for people who are watching this video.
Thank you for
Thank you.
very much, and we'll actually continue with another episode.
Sure.
What's the next episode?
The next episode, we will talk about the skilled worker. What are the process happening? What are the requirements for the certificate of sponsorship? And what are the requirements to apply for a sponsorship license?
Yeah.
Who can apply?
So it's
those
both
things.
for the employee and the employer.
Employer.
Okay. So keep watching us, and please, we'll see you in the next episode. Thank you.
Thank you.